Yeah, so I was into the definition of justice. So Jeremy Bentham once defined justice as giving people what they deserve. So what does it signifies? That you cannot keep justice in a watertight compartment, and there cannot be one specific definition of the term justice. It will vary from person to person. And when we discuss about principle of natural justice, principle of natural justice is a means to meet the end of justice. Principle of natural justice cannot in itself be said to be a justice, but what we say, it is a means to meet the end of justice. And that is why we say that whenever there is no law, we take the help of principle of natural justice. And whenever there is a valid law in existence with particular to any subject, we say that we cannot apply the principle of natural justice. And this is the universal application of principle of natural justice anywhere in any country. However, the term natural justice, where we call the term natural justice, and we say that that is the derivative of the concept of term just natural. And whenever we talk about natural justice, it it is somewhat infused with the moral theory, moral principle, moral justice. And the principle of natural justice infuse life and blood into legal process, both in judicial as well as administrative acts. Rule of natural justice are not embodied rules. Those are not written code. And the interest of justice equally demand that the guilty should be punished and that technicalities and irregularities which do not occasions failure of justice are not allowed to defeat the end of justice. Principle of natural justice are, as I said earlier, means to achieve the end of justice. It is not the justice, but it is the means to achieve the end of justice. They cannot be perverted to achieve the very opposite end, else that would be counterproductive in exercise. And you know that everything we say that whenever any lawmaking body frame a law, we hunt that for what purpose that law has been framed or for what reason any law is framed. But so far as principle of natural justice is concerned, we never hunt for any specific reason. And it is also the settled norms as has been laid down in various of the judgments at various parts of the world that reason principle of natural justice does not require any reason. It has never been a principle of natural justice that reason should be given for a decision. Because if I try to substantiate my argument with the concept, with the Kant theory, he proposed the word innate right. Now, what does this innate right means? We as a human being, we we acquire some right from our birth, no matter either we inherit or not, but we have innate right within us, and that cannot be taken out from us. And whenever we tend to apply those principles, whenever the question involves with respect to protection or with respect to freedom of our innate rights and responsibilities, principle of natural justice comes into place. Now, going into various maxims that you must have heard. The general principle of law is fiat justitia ruat coelum, which means let justice be done even though the heavens fall. So in order to start in order to find justice, be there can be law which could be framed to reach to a justice, but sometimes it may arise or sometimes situation may happen that there is a vacuum and there is no law in existence. And as right from the very beginning, I was hearing few of the professors and few of the speakers. Everyone was talking about human right, natural law, Ubuntu's. But to claim all those things, if there is an absence of law in implementing or in implementing the rights, they will have to look into the concept of principle of natural justice in order to claim those human right, and also the concept of Ubuntu philosophy, which I feel that is corollary to the concept of principle of natural justice. Now, moving forward, uh, we say that, like in my earlier statement, I said that we do not hunt for any reason when we talk about principle of natural justice. But whenever we talk about law, we we hunt for reason, and we there is a saying that reason is the soul of law, but that is not the case with the principle of natural justice. Now, if you if you try to trace the concept of principle of natural justice in South African constitution, uh, uh, you can see even in South Africa they follow two principles, which is quite prevalent in almost many parts. One is, as you all must be aware of both those principles, audi alteram partem, which means hear the other side. And second is nemo judex causa sua, which means no one shall be a judge for his own cause. On the other end, where in India, we have developed through the judicial pronouncement, judgment, and another concept in the principle of natural justice, that is post decisional hearing, which means even after a decision is made, an opportunity is granted to the party to have his say so that his right cannot go in vain, and he can have the absolute right to claim his natural justice. That was clearly laid down in the landmark judgment of Maneka Gandhi versus Union of India. If you see the section 24 of interim constitution of South Africa, it gave a right to lawful administrative action to the widest possible category of people, all those whose right or interest were affected or threatened. Similarly, the right to be given reasons in writing was extended to those rights or interests were affected by administrative actions. Section 3 of the Constitution, which is a litmus test for constitutional legality, which talks about just administrative action, and it talks about the first principle of natural justice, that is about fair procedure. And the concept of fairness procedure in South African judicial trend has been deliberated in various judgments. Uh, However, due to short of time, I will not run into all of the judgments. But here, I would like to cite one of the judgment of the year 1920, Dabner. You must be aware of this judgment, Dabner versus South African Railway, in which principle of natural justice was explained in terms, and I quote, certain elementary principles, spatially speaking generally, they must observe, they must hear the party concerned, these parties must have due and proper opportunity of producing their evidence and stating their contentions, and statutory duty must be honestly and impartially discharged. This signifies that the Supreme Court of South Africa has time and again has tried to incorporate the principle of natural justice through their judicial pronouncement. Similarly, even in the judgment of Marlin versus Durban Turf Club and others, 1942, 81-22, uh, the concept was deliberated upon, and it was stated that the principle of natural justice have not been excluded by the constitution as far as the coercive actions are concerned for domestic tribunal. So, as you all know, that principle of natural justice may not apply in legislative function or purely administrative function, but so far as judiciary and quasi-judicial bodies are concerned, it is mandate that whenever we have to reach to a particular conclusion, we will we are bound to follow the principle of natural justice. And as I said earlier, that principle of natural justice, it may not be backed by any reason, but there has to have a sound principle supported by the fair procedure, supported by the mass, supported by the people, supported by the people who are aggrieved. So sometimes situation arises that who can claim the benefit of natural justice, and it has been stated that principle of natural justice can be claimed by individuals whose existing rights include the property right as well. So those individuals whose existing rights and recognized liberties are being interfered may claim the benefit of natural justice. And who cannot claim the principle of natural justice? Those who are merely attempting to obtain potential benefit have no enforceable claim. Mind it, I'm using the term no enforceable claim. They might be having the innate right, but they do not be having the enforceable claim uh, in that particular situation to claim for principle of natural justice. And this principle of natural justice, it is actually a revolution. It is a renaissance, and with the development of human existence, it will change. It won't change. The base cannot change, but the ambit of principle of natural justice is definitely going to widen of himself, because it is dynamism in itself. It is a dynamic concept. You cannot keep the concept of principle of natural justice in a watertight compartment, like what I told you about India. Like, we have not confined ourselves only to the two principle of natural justice, but with due process of development, we came to know that no, one more addition could be made, that is post decisional hearing. And this principle of natural justice, as I told you in the beginning, it has its own it has accompanied us. This principle has accompanied human being with its existence. As you must have read, and I will conclude with
You kindly. wrap up.
Yes, with the judgment, I would like to quote the celebrated judgment of Copper versus Wonderworth Board of Work, in which it was stated that the first time the principle of natural justice, the concept of audi altram partem, was used even by the God when God did not pass a sentence upon Adam before he was called upon to make his defense. Uh, Adam, says God, where art thou? Hast thou not eaten of the tree of I commanded thee that thou shouldest not eat? That means he had asked, I believe that you have understood what I meant. That you must be aware of the story of Adam and Eve, and Adam have secretly eaten the apple. So God gave the opportunity to Adam to give his explanation, give him the opportunity to hear, and then only he gave the decision. So we in African we always pray to God, Gumbaya, my Lord, Gumbaya. So that do has a basis even in the principle of natural justice. So with this, I conclude my submission. Thank you so much for your patient hearing.